The Seventh Amendment opens the doors of our nation's courthouses to you and me. Because of this key component of our Constitution, we have the right to bring disputes before a jury of our peers. But the right to trial by jury is threatened today by the spread of something you may have never heard of before: arbitration. Arbitration is a private dispute resolution process that is binding, meaning arbitration decisions are legally enforceable. It takes place outside of our traditional courts. It is typically confidential and uses private judges, known as arbitrators, who are chosen by the parties. Arbitration might be appropriate when corporations are of similar negotiating strength and decide, based on the advice of their attorneys, that they want to resolve business disputes in this manner. But arbitration can pose problems for justice when everyday citizens are made to waive or give up their right to trial by jury before they even know the harm that could take place. For example, some corporations may require employees to agree to arbitration if they want to be hired, or they may ask you to give away your rights to trial when you buy their product. At this early stage, you have no idea about the company's behavior or the safety of their product, and yet you are being asked to give up your right to go to court. If you look closely at a contract, you may find that a business or professional is trying to get you to agree to arbitration, even though you haven't had any discussions about it at all. Arbitration language is being included in more and more legal agreements these days. It's happening so often that Judge Craig Smith and Judge Eric Moe write, "A person cannot open a bank account, obtain a credit card, buy a car, or use a cell phone without contracting away the Seventh Amendment right to trial by jury." They further state, slowly but surely, the widespread enforcement of mandatory arbitration clauses has chipped away at the basic tenets of contract law and of the fundamental freedoms upon which our nation was founded, the right to trial by jury. It can be very hard to appeal an arbitration decision, and when we funnel disputes outside of our court system, the law does not develop through new cases. By sweeping disputes into arbitration, which is private and confidential, facts are not brought into the light of day. We, as a community, do not learn about widespread wrongdoing that may threaten our families. And when large corporations hire the same arbitrators time after time, it can create the wrong incentive for the arbitrator to rule in the corporation's favor, not yours. So what can you do? Read documents very carefully before you sign them. Ask a lot of questions. And if you see the words arbitrate or arbitration, stop and think about whether you really want to give away your right to trial by jury. If you decide you want to preserve your rights, you can tell the other party that you will not agree to arbitration, and you can ask them to remove the language from the document. Rights lost are not easily regained. It is crucial that all of us preserve our right to trial by jury. This 7-part series explores the origins and importance of the Seventh Amendment. It is made possible thanks to the Aboda Foundation and generous supporters like you. Please share this episode with your friends and family, and join us to learn more in episode 7.